wake up in the morning and this is what you get. Bye-bye affirmative action, huh? The Supreme Court is coming for workplace diversity initiative next. Conservative justices made clear they are ready to bar affirmative action, not just by universities, but private employers too. Sometime next year, the Supreme Court will rule that private universities can no longer consider the race of applicants when deciding on whom to admit. That much was made clear from oral arguments in two related cases the court heard on Monday, October 31st. Halloween. They're going to make sure you remember this stuff. 6 of the 9 justices appear set to end affirmative action programs that have helped diversify American campuses for decades, suggesting strongly in their questions that any race-based advantage in admissions was inherently discriminatory against other applicants. But the court won't stop at the ivory tower. Its next stop is likely the workplace, where commonplace diversity initiatives will be found unconstitutional using the same logic. The thinking that leads conservative justices to bar consideration of race in university admissions will apply just as easily to corporate hiring practices when such a case inevitably reaches the court. In that sense, Monday's argument could be heard with even broader significance. Only a little racial discrimination. Justice Alito twice described college admissions as a zero-sum game in which one person's advantage is inherently someone else's disadvantage. Hiring, of course, is a very similar kind of marketplace for talent. Chief Justice John Roberts stressed that even considering race among a wide range of factors, which is a prevailing practice at most universities and companies alike, amounted to racial discrimination. When a lawyer for Harvard said race was rarely the deciding factor in its admissions decisions, Roberts retorted, "So there's only a little racial discrimination in the case." As a matter of law, the cases heard Monday will only affect public schools. Under the 14th Amendment, which prohibits states from denying anyone equal protection of the laws, and most private universities, under Title VI of the Civil Rights Act of 1964, which prohibits discrimination in programs that receive federal funding. Hiring discrimination is considered under Title VII, which guarantees equal employment opportunity at most private firms and the world's largest employer, the U.S. government, but the language of the Title VI and Title VII are similar. There's no reason to think the court wouldn't apply similar logic. If and when the court rules that the meaning of Title VI tracks the meaning of the Equal Protection Clause of the Constitution, barring the consideration of racial diversity in admissions, it would be a logical conclusion for the courts to treat the language of Title VII as having similar effect in the workplace, writes Harvard Law professor Noah Feldman. Don't have a clue what it means. Even the well-established American idea of a melting pot, that diverse groups are preferable to homogeneous ones, seemed to be up for debate on Monday. I've heard the word diversity quite a few times, and I don't have a clue what it means, said Justice Clarence Thomas, who has been a consistent voice against affirmative action even when the court has upheld the practice. The difference now is that his conservative bloc has grown into a supermajority. Diversity is a measure of a demographic dissimilarity within a group, as Justice Thomas well knows. His comment meant to question the now widely held belief, not just on campuses, but in C-suites and most households, that racial diversity is valuable and worth seeking. In this bedrock principle of modern American life that the court treats with great skepticism, university administrators say ending race-based preferences in admissions will lead to far fewer Black and Hispanic students at selective schools. They know because that's what happened in states where public universities have already been forced to stop considering the race of their applicants. It will also weaken the pipeline of talent applying to jobs in competitive industries. Though the cases in front of them were limited to university admissions, many of the justices spoke much more broadly about racial preferences. Brett Kavanaugh, whose appointment under President Trump helped swing the court rightward, seemed to speak for the new majority when he declared racial classifications are potentially dangerous and must have a logical endpoint. I guess the millennials and the Z's get their wish. There will be no more race consideration. Race doesn't exist anymore. Okay. He's claiming the mantle of prior Supreme Court decision that contemplated a time when racial preferences would no longer be necessary to achieve a diverse student body. Amy Coney Barrett, another of the conservative justices, suggested diversity initiatives were inherently flawed because how do you know when you're done? The implication was that the era of sanctioning racial preferences in the U.S. is coming to a close and that college admissions just happen to be the specific question before them. How can you do diversity without numbers? Feldman, the Harvard law professor, predicts that lower courts will start to look skeptically at programs that encourage a diverse workforce. Even before the Supreme Court officially speaks to that question, firms will be more circumspect about how they describe diversity initiatives, which is hard to imagine because U.S. corporate law is already consumed with paranoia about employment discrimination. The impact will be far greater than changes to university admissions, not only because more people work than go to school, but also because employers emphasize diversity of gender, sexuality, and other traits in addition to race. The most likely result, I think, is that corporations will begin to back away from rhetoric that emphasizes the concept of diversity as quickly and quietly as they can, Feldman wrote ahead of Monday's argument. All of those dramatic changes will come before the Supreme Court actually weighs in on corporate diversity initiatives that are now commonplace. For instance, saying the company wants to hire more women engineers, setting a goal for the company's workforce to reflect demographics of the community it serves, considering a candidate's gender, race, or ethnicity when hiring for a role on a homogeneous executive team, or creating rules about the composition of the finalist pool. For instance, that the company must interview at least one minority before any position. It's impossible to know precisely how the court will rule when presented with these situations, but nothing about their views on affirmative action suggests a desire for moderation. The court's stance appears to be that any consideration of race that results in unequal treatment is unconstitutional, which would put all of the diversity initiatives above on the chopping block. As Roberts put in a 2007 decision that summarized this view, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. There's not much credence given by the conservatives on Monday to the notion that affirmative action policies were meant to address existing inequities. Justice Elena Kagan, Sonia Sotomayor, and Ketanji Brown Jackson from the liberal wing advanced those arguments, which are pretty mainstream in the U.S. Prohibiting the consideration of race, Justice Jackson said, seems to me to have the potential of causing more of an equal protection problem than it's actually solving. But the conservative view that will prevail in the admissions case and in hiring cases to come is seeing that race at all is the original sin. How can you do diversity without taking account of numbers, said Justice Neil Gorsuch, who rounds out the 6-justice majority. Here at least was a very good question. You can't. Not well anyway. Making it legal for schools and companies to take account of their numbers. Are black students on the campus fairly represented? Why are there no women on the sales team? Is precisely the aim of the conservatives who brought these university admission cases to a newly sympathetic Supreme Court and are coming for corporate hiring next. Because the goal is not to do diversity at all. And that was from Quartz. And Quartz is an overseas newspaper. But anyway, I guess certain people have gotten their wish. I guess you will have no more affirmative action. There will be no more race consideration. No more race consideration. What do you do with that? What's going to happen? Okay, you get to be Negroes again. I guess the civil rights era worked too well, and I guess it's over. Because affirmative action was your check. Did it work well? No. They give you some protection? Yes. You had some protection. You got your 10%, your 13%. The vast majority of people that it actually worked for was actually white women. And I guess white women have come far enough that they don't need it anymore. So affirmative action is no longer necessary because white women already have their money, already have their position, already have their power. And I guess white men are perfectly willing to share it with their women. So I guess you Negroes are no longer necessary. So what is next? Voting rights? Is there cotton that we can pick? The world will never know. Maybe maybe the Mexicans will share jobs with us. Maybe we can go out and sell fruit on the corners and fight for territory. I'm just joking, but not joking. And we're fighting over a freaking gender war. And we think that the black people's biggest problem is black men and women don't get along. And black relationships are key to the black community. I guess if, we've already done abortion because they need more white numbers. And since they need more white numbers, they need more white jobs. So guess where they're going to take them from? They're going to take them from you because they're not going to take them from white women. So the only group they can take it from is black people. So I guess the permanent underclass that Dr. Claude Anderson was talking about will be solidified. Supreme Court has spoken. You Negroes get no more special treatment. Your path to equality is over. So what do you do with that? It's a good thing that I'm old. And I don't have to face this because I was born in the sweet spot. I was born in civil rights. I came of age during affirmative action where I did get preferences. I did get a shot in the arm. They hired black people. They had to worry about discrimination. And my children do have a piece of it. Unfortunately, my grandchildren will not. Hopefully, America has moved past its racist past. But as what happened in Germany, I doubt it. So you worried about black women, and you thought you're going to defeat white supremacy. I was just listening to Omawale talk about fighting white supremacy and how they were doing it. But I guess this snuck right through the door because I've never heard him talk about this. But I guess now you have something to fight. All you pro-blacks and you feminists and you intersectionalists and stuff like that have been needling men and siding with white women in this rhetoric. Now you get to play Negro all over again and see what it's like. Good luck. Good luck. I am fascinated to see the results because I'm getting tired of hearing these cats talk about no more race, siding up to white people, saying race doesn't exist, and the civil rights blended all people together, and there's no more discrimination. Discrimination was on hold, and discrimination had a shield. And so now you have Twitter where they can call you Negro in public and defame you in public, and now they're getting ready to take away all your protections. Oh, this is rich. This is rich. You guys thought that the war was over and the civil rights era worked and there was no more work to do, and all of a sudden up pops the devil, huh? And basically, black pill in me is laughing his ass off. It really is. He wants to laugh his ass off because it is what it is. And you get what you fight for. And your neocons and your neoliberals have planned this all along because white women don't need you anymore. And what did the funky academics say? The only freedoms and the only stuff that you get is what white women are willing to fight for. And white women don't need affirmative action anymore because they got their money. You don't. Just like when they got the right to vote and they got a majority, first thing they did was cancel you. So now that white women have gotten political power and political clout, and they've got the Me Too's and moved into the C-suite, guess what they're going to bar from getting into the C-suite? You. Good luck. Like I said, this is a black pill moment. I hope you guys recognize it. And you millennials and Z's that said race doesn't exist, you're going to have your chance to prove it. So get with your white friends, your white associates, and your white buddies, and you guys sit down and have a beer and hash this out. Anyhow, with that, I'm going to jump off here. This is BGS out. I'll see you guys on the next one. Peace.